All right, we'll get started on the next topic. So the next thing I had on the agenda is a discussion about Brady and Giglio. But before I start on that, is there any questions, topic, anything that you have that might not, that we're not going to specifically cover here in the material, but things that have come up that you might have questions about, or anything that's going on in your department? Nothing new? Okay. So I wanted to talk for a little bit about the Supreme Court standard in Brady and Giglio. Does everybody know what I'm referring to or what I mean by that? And for the dispatchers, it might not be overly relevant or important, but there is always, some concern about dishonesty or untruthfulness when dealing with the employer, and that can take a number of different forms, and we'll sort of talk about that once we go through the material real quick. But so Brady is again a U.S. Supreme Court case, Brady versus Maryland, and essentially what Brady said is that the prosecutor has to turn over evidence that could be exculpatory to the defendant. So, if you're out investigating and you find information, or there's, DNA evidence or something that could be potentially favorable to the defendant, you as the officer have the obligation to turn that over to the prosecutor. The prosecutor has an obligation to turn that over to the defendant, whether they requested it or not. And the other area, or the other case that I also wanted to get into, is Giglio, which says that not only does it have to be evidence, but it could be information or background that could weigh on a witness's credibility. And so as police officers, if you are determined to be untruthful or to have done something that could violate, like Giglio, then your credibility would be potentially could be questioned when you're testifying. Does the prosecutor have to turn over that information as well? Yes, generally the standard is, but there are some limitations on that, and we'll kind of go through that. But I wanted to bring this up for two different reasons. First of all, because you are the ones out in the field. You have to gather the information and interview witnesses. It's your credibility that's going to be in question when you testify in court. But also because the employers, many employers recently have started to use this Brady Giglio issue in order to discipline or terminate employees that they otherwise couldn't. And so it's something that has, sort of come about in the last couple of years. We've seen it here and there. Yvonne had a case just recently where this was a major issue. And so I wanted just to be aware of that, keep it on your radar, so that if you hear this stuff going around, what it is it means and how it affects you. So I'm going to more focus on issues or information that could weigh on a witness's credibility. So you as a employee, and let's say you have information, or you have to testify in a criminal case about, if you're a dispatcher, what happened, what was the call? If you're a police officer, did you respond to the call? What was happening? What was your investigation, your incident report? What evidence did you gather? All of that kind of stuff. All of that is fairly common for the criminal case. The issue where this sort of arises and comes up a little more is where somebody has some information in their personnel file or has been previously disciplined for reasons that could potentially be considered to be dishonest or untruthful. So as a practical scenario, let's say 2 years ago you called in sick. We'll use the sick analysis. You called in sick, but you weren't on sick leave. You were actually doing something else. The employer found out about it. They put a note in your file that says you're given a written warning for abusing sick leave and whatever the circumstances were. Could that be considered to be some type of crime or a offense of dishonesty or untruthfulness? Potentially, yes. And if there's a circumstance where, in a separate incident, you're investigating something, you put in your police report all of the different things that happen, but it turns out when comparing it to the body cam, that wasn't exactly 100% accurate, or maybe there was something different that happened, and they say, well, we found that your report wasn't completely accurate, we think that this was untruthful or something like that, you get some type of written reprimand or, suspension, whatever the case may be. But that goes in your personnel file. Now we're going 2 years later, you're involved in a completely separate incident. You have to testify in court. The prosecutor says, do you have anything in your file that I need to turn over to the defendant? All of that information, all of those prior discipline and that, potential prior bad acts of untruthfulness or dishonesty or something like that, that has to be, according to the prosecutors, that has to be turned over. They'll take that and then turn it over to the defendant. So what a lot of employers are saying is, because you have these issues in your background, in your file from years ago, we may not be able to use you as a witness because the defendant's going to question your credibility, you're not going to be a trustworthy witness, so basically you're no good to us anymore as a police officer. So we're going to terminate you because you can't fulfill the essential functions of the job anymore. You have to be able to go out and investigate and testify and do all of the things that a police officer would normally do. And you would think I'm making this stuff up. Am I making this stuff up, am I?
No, you're not.
Good answer.
Public record required.
And usually it's not just as simple as, in this particular case, we need to turn this information over and then that's bad and all that kind of stuff. Usually what happens is that they're looking at the officer because of some other reason, right? They don't like this male or female. They're starting to build this file of, written reprimands and suspensions and stuff like that for stuff that maybe is questionable. But then they're going to take all of this, background information and say, oh, by the way, because we suspended you here, we fired you, and when you go to get your job back, or you go to fight that suspension or go to get your job back, then they're going to say, yes, he did all of these things, and oh, by the way, we can't use him anymore because he's a bad cop, right? He was untrustworthy, or he was untruthful in this prior investigation, so we can't put him back to work. It's just another reason why, an explanation they give to the arbitrator as to why that arbitrator should not reduce the suspension or put somebody back to work. Yeah, those are usually the scenarios that things play out. And for you on the ground on a day-to-day basis, does this really have a big application? No, other than, my only point is that from a public's perspective, from the employer's perspective, you have to be perfect all the time, right? There can be no errors, there can't be any missed information in a report. You obviously did something bad, that's why it wasn't in there. I mean, that's the perception that is out there. Nobody can operate based on perfection. I am certainly not perfect. I make a lot of mistakes, but we need to operate to the best of our ability to be honest, even if we make a mistake. People make mistakes. I've made thousands of mistakes. But we make mistakes, and we can explain those mistakes or take the discipline or the consequences for that. Where you get in trouble, or where employees mostly get in trouble, is where they start to shade what the truth is, right? Because they don't want to get in trouble. They don't want to think that they did something wrong, and that's okay. That's fine. But now you're starting to go down this whole other area that we don't want to be in. We don't want to have to be arguing about your trustworthiness and your honesty and all the other things that are going to go into it, because that's going to come back at some point. So for you, I mean, that's basically the point of what I'm trying to get to here, is that we need to be in good faith, as honest as we can under the circumstances, because we don't want to have to deal with these issues later on down the road, 2, 3 years, 5 years down the road. But as a practical matter, so, what ends up happening, in my view, and there's a difference of opinion in the courts over this, is that when does that information have to be provided to the defendant, and when is it relevant for purposes of the criminal prosecution for the trial? Now, I don't think, in my reading of the cases in the Sixth Circuit Court of Appeals, is that those types of incidents, let's say you had incidents 2, 3, 5 years prior, those are not relevant to your honesty in this particular case, right? I investigated a crime, I gathered the evidence, I'm getting called in to testify about that, I did everything I was supposed to do. Anything that happened before in my past isn't relevant. That shouldn't come up. And I think that's currently what the Sixth Circuit determined. But there are other circuits out there that say, no, any of this information in your background is relevant, needs to be turned over, and you can be questioned about this while you're testifying. It's up to the court to decide. Once all of this information is disclosed to the defendant, it's up to the court to decide whether it's relevant or not, whether it's admissible or not. So just because this information may be out there, in my opinion, the employer can't use it to say, well, this is a bad cop, this is a bad officer, they were dishonest or untrustworthy in the past, therefore they can't be a credible witness now. I think the employers are stretching sort of this, argument in order to justify what they're doing when really they have no justification. So, that's sort of the context in which the employers are using this information. Yvonne, you want to talk not specifically about your case that you had just a couple years?
What happened was an employee, an officer was terminated while he was on probation.
Arguably on probation.
That was our argument. And then after a couple years, there was a new employer. They rehired him back, and he served his probationary period the second time. There were some issues that arose. People were digging into his past from when he was employed the first time. And then they indicated that he lied on his application and things that he did in the military that were untruthful, yet they still hired him the second time. So when we went to arbitration, the issue was whether or not those things could have been brought back. Tried to argue he was rehired. The employer at that time knew what his background was. Unfortunately, they said that he was an employee, a probationary employee, and by, I think, less than 10 days, he missed the time frame, and we were unsuccessful at that time, but they tried to claim that he was Brady. They could not use him because he lied on his application, and he allegedly took like MREs when he was in the military when he was like 20. And that showed that he was untruthful and essentially were unsuccessful in that case. But
yeah, and we didn't necessarily have to get to the point at arbitration about whether this information was relevant or not, or whether, I don't know if any of you out there, you hear this talk about a Brady list, that the prosecutors are creating a Brady list. That means everybody in your department that has any type of prior discipline of bad acts or untruthfulness, your department, your chief or whoever it is going to compile the list of all of those officers. They're going to give that over to the prosecutor so that the prosecutor knows if you come to testify, you're going to be on this list, and they're going to go back and look at all of your background and turn all of this information over. There is nowhere in case law or anywhere where it talks about a Brady list. The employer does not have to create a Brady list. I don't think it's even appropriate because, again, this information isn't necessarily relevant to each particular case. If something happened 10 years ago, it doesn't matter.
And there's the ability to rehabilitate them
Right.
at trial.
Right, even if you testified at trial and said, yeah, this happened 10 years ago, but since then I've been a perfect cop, nothing's happened, I have a clean file, you can testify to that, right? That doesn't mean that you can't ultimately testify. But so we didn't have to arbitrate that particular issue, but there was a lot of debate with the prosecutor about, because the prosecutor sent a letter that said, we're never going to use this guy again, he cannot testify.
So we tried to negotiate quite a bit before we even got to arbitration, saying, you're wrong, you're absolutely wrong, it doesn't apply, you have the ability to rehabilitate him even as your witness in a case. There was some backdoor politics and the prosecutor didn't like this particular officer. So we never even got to the whole Brady issue because we never made it past whether or not the case was properly before the arbitrator because he was a probationary employee. So we dug into the whole Brady issue pretty well and talked to the prosecutor quite a bit. And it just didn't work out, unfortunately.
Yeah, in that case, but and there have been other, like I said, there have been, probably 2 a year that seem to come up when we're dealing, particularly when we prepare for arbitration, that the employers are using sort of this tactic or this ploy to say, well, even if he were to get his job back or he or she were to get their job back, we can't use them anymore because of this Brady issue or the Giglio issue. And I just, from my perspective, I think that's wrong. If you're anybody in your department, your chief is saying, hey, we need to compile your personnel file and turn this over, give us a call. We'll see what we can do about it. I don't know if I can necessarily prevent it, but I think a lot of them are wrong on the law. First of all, that's the basis. Any questions about sort of those two things? Yeah.
So ours is set up for probation is a year and you can't join the union for a year, so that would never be an issue for us. Like, how did that,
Anybody can join the union at any time.
really, ours is set up that you can't join until you get your year, and
It's-
so that's not accurate?
It says you can't, does a collective bargaining agreement say you cannot join for 1 year?
I don't know.
Or does it say you serve a probationary period, you cannot file a grievance based on discipline within that 1 year period?
But you still can become a member
Yeah.
of the union.
Okay.
Yeah.
I was under the wrong premise on that.
Yeah, no, that's, because that happens, you get every other, that employee receives the benefits of every contract other than specifically the discipline because you can be terminated at any point during your probationary period, but you're still getting your wages, you're still getting all the other benefits of the contract.
And, what district or what city are you from?
Brian.
Okay. Well, we'll take a look at the contract. I would doubt that we would agree to language that says you could not join the union. You may not get the grievance and arbitration process for discipline or if you're terminated, because they can discipline you for any reason during the probationary period. But you would still, and I encourage everybody, this may sound self-serving, but I encourage everybody to join from day one, because your second day on the job, you may be involved in a use of force incident. And if that goes wrong and you're going to be subject to criminal prosecution, we'll provide you an attorney from day one, as soon as you join the union. So, a lot of people say, well, I'm just going to wait the 90 days or I'm going to wait the 6 months or whatever it is on the contract. That means, if something happens the first week out in the job and you need to go out and hire a criminal attorney, you're going to pay $25,000, $50,000 probably for that defense. So we provide that. And the other area where this seems to come up a lot, and I actually just recently went through an arbitration, is when the employer goes back and looks at your application. So I don't know if you had to fill out an application form when you got your job, or whether you submitted a resume, or whatever the circumstances were that you filled out in order to first get your job. If you did not list every employer on there, that you've ever had in every place that you've ever lived, they're going to go back and see you lied on your employment application. We would have never hired you in the first place. And I literally, I'm waiting for the arbitration decision on this because the employer used this. They had really no reason for terminating the employee, in my opinion. I mean, they had their reasons, but I think they were wrong. But during the arbitration, then they brought up the application. They asked them specifically. So you said you worked here, here, and here. Here's your employment application. You didn't list them anywhere on the application. Nope. So they're saying that that was a dishonest or untruthful application, and based on that, they wouldn't have hired the person in the first place. That's another reason or another way of, getting what they want through the arbitration process.
They should fire the detective who did the background check.
Well, yeah, we asked him, so who did the background? The captain did the background check. Did you find all this stuff out? And he said no, but that doesn't matter, right? So that's,
What type of employment was it that, did it impact his current job as an officer, or was it just saying, hey, I worked at McDonald's when I was 17 and I failed to be enlisted?
Yeah, so that's a good question. In this case in particular, while we have a few minutes, I'll just give you the factual background. I think the record is closed, so I'm just waiting for the decision. But Officer B, he was the good officer, right? He called the union. Well, in fact, he did not call the union right away. So he's Officer A. That got him in trouble in the first place. He's driving down the street in a marked cruiser. He goes to turn into a driveway. Car behind him, it's a pickup truck, big red, older pickup trucks coming down the road about 25, 35 miles an hour. He didn't know exactly. Goes to cut around him, goes over the berm, goes over the white line, goes onto the berm, goes around him probably at about that speed, 25 miles an hour. And he later testified at the arbitration he probably came within a foot or two of hitting the cruiser. Lays on the horn for about 2 or 3 seconds, goes around, keeps driving up the street. So our guy doesn't end up making the left-hand turn, ends up pulling out and getting behind him. Is running the plate and stuff, finds out where it's at. The guy comes to a red light. The red light turns green, he turns right. The officer follows him, turns on his lights and siren, comes up to another red light. They stop at the red light. Turns green, the guy keeps going. He drives about 300 or 400 more feet and pulls into his driveway. So our guy follows him, kind of pulls in like half on the driveway and kind of blocks him in. Before he even gets out of the car, the guy exits his driver's side door and is walking back, and there's video of this. He's actually walking back towards him, and he's kind of doing this with his hands. Gets about halfway or close to the cruiser door. Our guy gets out. They kind of meet each other like next to the cruiser, and they start walking back to the driver's side door. Somehow or another, they get into a scuffle. There's sort of like this hand, according to our officer's version, there's sort of this hand wrestling. The guy starts pushing him, that kind of stuff. A passenger in the pickup truck comes out around the back of the vehicle, stands at the back corner, and she's got an 18-inch wooden baseball bat. So he tells her, while he's still like trying to deal with the guy, he tells her, hey, don't come any closer, I'm going to pepper spray you or whatever. So she comes close enough that he could reach her with the baseball bat still in her hand. So he does this and pushes her backwards. Pushes her in the chest. She falls backwards onto the ground. Fortunately, a different department ended up showing up at the same time. They ended up handcuffing the two individuals. The rest went from there. So our guy was terminated. Do you know why he was terminated? And I'll get to the one point, but they alleged initially that he was out of his jurisdiction when the first traffic violation stopped, and that he had no reasonable suspicion to stop the vehicle in the first place. The second one was excessive use of force. So that was their justification for terminating the guy. And so as we're going through, there's going to be a punchline to this story, so you guys got to wait for that. So they terminate him. We go through the grievance process. We go to arbitration. So as a separate basis to say that this guy cannot work is that he didn't disclose 2 previous security jobs that he had on his application. And they actually go back and find like his boss from 10 years ago that said, yes, he worked for me. I had problems with him. I think he was overly aggressive in his job, and, you know, basically smearing the guy from however long ago that was. And that's the separate basis why they can't hire him back, because he's clearly a bad guy and he lied on his application. Okay, so going back to the incident, how many of you think he should have been fired? First of all, there's an argument. The street that the original incident occurred on was an adjoining property to the district. And their policy says you can make a stop on an adjoining property. It was on the adjoining property. There's no question about that. They said that. But when he turned off of the street, he was actually getting out of his jurisdiction. So once you made the right-hand turn at the first red light, he was going out of his jurisdiction. But they said he had no reasonable suspicion to stop him in the first place. Anybody think he should have been fired?
How long of an employee has he been?
About 4 years, 4.5 years.
Required discipline?
Yeah, he had some tardiness. Like he was late a couple of times. He got a couple written reprimands for that kind of stuff, but nothing significant in his file. How many thinks he should get reinstated? Somebody didn't raise their hands. What do you guys think? Are you on the fence?
I didn't hear what you said.
Should he have been reinstated? Should he be reinstated? Okay. Would it make a difference if the gentleman and the lady were 72 years old? Okay. Well, so that was another reason why they were saying, yeah, that was another reason why they were saying is that when he first got out of his car, he should have just said, hey, what's going on? Do you guys need my help? You know, is everything okay? You know, while the guy's like coming back to his vehicle in an obviously aggressive manner and waving his arms, and then they also ultimately get in this hand wrestling stuff. They did not have body cams. Only at the point where the female was already on the ground when the other officer showed up was there a body cam.
No video of the car though?
Not in the vehicle. Nope. The only thing that we had was a video from a gas station across the street. And of course, there's like this big dump truck, like blocking the view. So all you can see is their heads, basically. You see the guy's head come back here. You see this guy get out. They start walking back here. You see the lady come around the car, and then you see her fall backwards. That's all that was on video. So they terminate the guy in October. They send it over for criminal prosecution, which they turned over Garrity information, by the way. That's why I know there was not a Garrity violation, because they didn't end up charging him and indicting him. But they admitted during arbitration that they turned over the Garrity protected information to the prosecutor. February, the prosecutor's office comes out with an opinion that his actions were not excessive or unreasonable, and that his actions were lawful, is what they said. So when you get to arbitration, what the employer argued is, yeah, but that's a criminal standard. That was beyond a reasonable doubt. They couldn't determine that. But under our policy, we felt it was unreasonable and excessive. So that's where we're at. We're waiting for a decision back on that. I will let you know how it goes, but I think under any circumstances, they were wrong in every respect. So, you know, they said he didn't have reasonable suspicion because the guy honked at him, right? The guy was just trying to go around him on the berm, honked at him, and then our guy became, you know, enraged and was tracking him down, basically.
So the fact that you're not allowed to pass on the right side doesn't matter?
No, not to them. Not even crossing over the solid white line to go onto a berm in a residential neighborhood with a sidewalk.
Good. I find it interesting, and I think there are more stories of it, that when the city realized how whoever the representative body was, the employee body, realized how weak their case was, they started piling more and more things on. Instead of taking a moment back off and saying, maybe we were wrong, our interpretation
Oh, God,
was
no,
wrong,
that never
or whatever.
happens.
Right.
It's just, to make them, they go clear back to pre-employment and everything else to try to throw more on there to try to get rid of this guy rather than saying, we're looking at this specific incident.
Right. And so once the prosecutor's office came out with their opinion, which was about 3 months after the fact, why didn't you go back and reevaluate at that point and say, hey, this really wasn't an excessive use of force situation. Maybe we give you, if it's debatable about whether, he exceeded his jurisdiction or whether he had the right to pursue in their policy, it's not a police department, so they don't have quite the same powers as a sworn police officer. They are sworn officers, but within their jurisdiction it says you cannot pursue outside of the jurisdiction. So, but even if there's an argument about whether there was a pursuit or whether it was outside the jurisdiction, give the guy a 1-day suspension and say, hey, don't do it again, or here's your training, here's what the policy says. You don't terminate him under the circumstance. And this is a young guy. I mean, he's upper 20s, so he's never going to be able to work again based on this. So that's what employers do.
So he hasn't worked since last October.
He has been out since October, yeah.
When was the hearing?
We ended on August 27th, I think. We did briefs, so it's going to be about 60 days. I think we have 60 days for a decision.
A year.
Yeah, he'll be out over a year. I'm guessing probably December by the time we get the decision back. All right, so those are the kinds of issues that come up. Any thoughts, discussion about Brady or Giglio or anything that you guys have seen? Has that come up in your departments at all? Nothing?
I mean, not that we know of.
Right. Yeah.
Our prosecutor might have a Brady list that we're unaware of.
Well, just recently, the Cuyahoga County Prosecutor's Office sent out a letter to all the police chiefs saying they want a list of all of your officers that have had issues of dishonesty. And, we've said, well, we don't think that's appropriate. You don't need to provide that. You don't need to create this list. If there's an issue that arises during that case, right, if you're the officer and in your incident report you falsify a report, or you didn't turn over some evidence that you found that was exculpatory, I mean, yeah, you have a real problem in that case. But I don't think they can go back years and say, well, you had these prior discipline, that kind of stuff. Right? Okay. Anything else that you want to talk about, bring up, discuss? Anything like that? Okay, George is going to do the use of force and officer-involved shooting and sort of our response to those types of incidents. I think he was going to be back here. Oh, actually, I'm doing that section. Sorry. Joe was going to do that section. Joe is our attorney in Columbus. He's got an emergency TPO or CPO hearing down in Columbus, so he's not able to make it. Why don't we take a 10-minute break and then we'll come back and talk about that section.